Hey guys, welcome back to my channel and welcome back to Coffee Talk, where I take an interesting topic and give it to you in the time it takes to drink a cup of coffee. So, go grab yourself a cup of coffee. Make sure that it is piping hot. Add some cream and sugar to it. My favorite creamer is French vanilla non-dairy creamer. And if coffee's not what you do, perhaps a nice hot herbal tea is more you. Make sure that it is steeped to perfection. Add your honey or agave to it. My favorite is lavender tea. And if coffee or tea are not what you do, perhaps a nice fruity smoothie is more what you do. And let's sit back and get ready for today's hot topic, which is the case of Adriana Smith and Georgia's Life Act law. Is it moral to keep her body alive to deliver her baby? So y'all, let's sit back and get ready for this hot topic. Okay, so before we get deep into this, let me just say for the record that I am of the opinion that choosing to give life is a woman's individual decision. However, I do consider having an abortion. I do consider that to be unaliving a person, even if they're not born. So now, let's get into this crazy case. This is a tragic and ethically fraught case involving Adriana Smith, a registered nurse from Georgia who was declared brain dead after a sudden medical emergency. And the sudden medical emergency, put it into perspective, she had gone to the hospital the day before complaining of headaches and requested a CAT scan, but was denied one and sent home. The next morning, her fiance found her gurgling and trying to hold on to breath. A CAT scan was done and they found that there was something going on in her brain, which we don't know if it could have been prevented if it had been caught sooner. Due to Georgia's strict heartbeat law, which prohibits abortions once fetal cardiac activity is detected around 6 weeks, her body is being kept on life support to sustain her pregnancy. And I don't know about y'all, but this case has raised profound ethical and legal questions about bodily autonomy and the definition of death and the moral implications of forcing medical intervention on a deceased woman for the sake of a fetus. Because once she's considered brain dead, she's legally dead. Georgia's Living Infants Fairness and Equality, or Life Act, enacted in 2019 and upheld in 2022 after the overturning of Roe v. Wade, bans abortions once a fetal heartbeat is detected, with very limited exceptions, like rape or incest or life-threatening medical conditions. To me, someone being declared brain dead is a life-threatening medical condition. But this law grants personhood status to embryos, meaning they are afforded legal protections similar to those of born individuals. In Adriana Smith's case, because her fetus still had a detectable heartbeat, doctors were legally compelled to continue life-sustaining measures despite her being brain dead until the fetus could potentially be delivered. We are now over 90 days from that. At the time of her being declared legally brain dead, she was 9 weeks. We are now at over 21 weeks. But my question is this going to give us a viable fetus by keeping this woman's body alive? And what does this say from a moral and spiritual perspective? Under U.S. medical and legal standards, brain death is considered irreversible death, even if machines temporarily maintain heart and lung function. Once brain activity ceases, the person is legally dead, and further medical intervention are typically discontinued unless organ donation is planned. But, however, in Georgia's heartbeat law, it complicates this standard when a pregnant woman is involved. Hospitals may fear legal repercussions if they withdraw life support, even in cases where the mother has no chance of recovery, which is the case in this situation. The Adriana Smith case forces a difficult question. Does the state have the right to use a deceased woman's body as an incubator against her and her family's wishes if she had an advance directive stating she did not want prolonged life support? Could Georgia's law override that? And let's talk about the moral status of all this, because proponents of the heartbeat law argue that the fetus has a right to life that justifies maintaining Adriana's bodily functions. However, on the flip side, critics argue that a brain-dead woman cannot consent to continued medical intervention, making this a violation of her posthumous rights. Another thing to consider is the medical futility and resource allocation, because keeping a brain dead patient on life support for months requires significant medical resources, including ICU beds, ventilators, and round the clock care. Ethics question whether this is justifiable use of resources with other living patients may need them. And my question is, who's paying for all of this? Is the state of Georgia going to pay for all of this, or is her family going to have to pay these medical bills for keeping her body alive? And what about the psychological impact on the family? Because Adriana's family is forced to endure prolonged grief, watching her body remain mechanically sustained with no hope of recovery, and the emotional toll of waiting for fetal viability with no guarantee of a healthy birth adds another layer to their suffering. And unfortunately, this is not the first time with such a scenario arising. Melissa Munoz, 2013, in Texas, a pregnant woman was kept on life support against her family's wishes due to Texas having a similar law. A court later ruled that she must be removed from support. In Ireland, 1992 had X case where a pregnant teen was denied an abortion despite suicidal ideations and leading to legal reforms. And these cases just highlight the conflict between fetal protection laws and individual rights. Adriana Smith's situation exposes the harsh realities of fetal personhood laws when applied to brain-dead pregnant women. While the intent of Georgia's heartbeat law is to protect unborn life, its application in cases like Adriana's raises serious ethical concerns. Does the fetus' right to life supersede a deceased woman's right to dignity? Should hospitals be forced to prolong artificial support for a legally dead patient? And what happens when a woman's advance directives conflict with state law? This case underscores the need for clear legal exceptions in abortion laws to account for medical futility, brain death, and respect for the deceased. Without such provisions, laws like Georgia's risk imposing profound suffering on families in the name of fetal protection. Well, guys, I have come to the end of my commentary on this rather deep and heavy subject, but I will be back again with more. I think it's time for me to go definitely get me a double helping of a cup of coffee so that I can start working on the next topic. I'm going to leave my resources and references that I use for this topic down in the description of this video. And I definitely want you guys to come and sound off on this topic in the comments. But if you are not already subscribed to my channel, what are you waiting for? You need to go ahead and hit that subscribe button, double tap it so that you get all of my upcoming commentary, and make sure that you are also, if you aren't doing it now, following me on my other social media. You can find me over on TikTok and on Instagram as DC The Purple Diva, and you can find me on my other YouTube channel, The Purple Diva Den, where I do spoken word. I will see you guys in the next one. Until then, I offer you peace and blessings from the West Side. I'll see you next time. Bye, you guys. I'm out.